Rise, Quick County Superior Court is now session on Timothy Walmsley presiding. Please be seated.
That's an ominous start. Any idea where that's coming from? All right, good morning. We're on State of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. Any idea where that feedback's coming from?
We're fixing to get IT in here.
Okay, let's get the, we'll work through the feedback in just a second. Let's see if we can get started, though, without too much of an issue. All right. The defendants are present, represented by counsel. State is here, represented by the district attorney's office. The plan this morning is there are a couple of motions that are pending. There's some motions to intervene. We plan on starting jury selection today at 1 o'clock, so I wanted to make sure that we addressed any issues with regard to jury selection. And if there is any particular motion in limine that we have to address now from a timing standpoint, I want to give the parties the opportunity to go ahead and do that. But really the plan this morning is to get organized so that we can go ahead and start addressing the panels this afternoon. With that being the case, anything from the state as a preliminary matter?
Nothing from the state, Your Honor.
Anything from Travis McMichael?
No, Your Honor.
Anything from Gregory McMichael?
You know, you're just wanting to hear about other motions pending that don't have to do with jury selection or anything that's...
No, what I'd like to do is address anything having to do with jury selection. And then depending timing-wise, if there is something from a planning standpoint with a motion in limine that's sitting out there, because again, we've got a little bit of time before we actually get to openings in this case and get into the evidence. If there's anything that we need to address from a timing standpoint, I'm happy to try to address that this morning.
Nothing besides voir dire issues, Your Honor, for us, on behalf of Greg McMichael.
From Mr. Bryan.
Nothing besides voir dire issues, Your Honor. But we do have some of those.
And I know, Mr. Goff, I've received proposed general questions from the state as well as the McMichaels defendants. I have not seen any from you. Do you plan on submitting any?
We have no general questions, Your Honor. And furthermore, we're withdrawing the previous request for a juror questionnaire, which I think the court's pretty much already denied it, but we would withdraw that. We have no general questions.
Thank you. All right. All right. What I'd like to address first then, I've got at least two motions to intervene. Make sure I've got both. All right. The first is filed by, let's see, Mr. Clyde, Mr. Fugate. It's a motion to intervene to ensure access to jury selection. Are either of those individuals here on behalf of the Associated Press, AJC, CNN, Court TV, Media Convergence Group, doing business as Newsy, Cox Media Group, as well as some of their affiliates and others?
Good morning, Your Honor. My name is Leslie Gaither on behalf of the media interveners as well as Rachel Fugate.
All right. If y'all just come on forward then.
Thank you, Your Honor.
morning. Is there any objection to the interveners on the issue of access to jury selection?
No, Your Honor.
No, Your Honor.
All right, we'll go ahead and permit the interveners on the issue of access to jury selection, more specifically on the motion by media interveners to ensure access to jury selection filed October 14th of 2021. Go ahead.
Thank you, Your Honor. I will keep it brief. Basically, we wanted to address three things in our motion. One, I think, is already taken care of. It was just a little bit of kind of confusion in the air about the media folks having their electronics in the overflow room. I think everybody who has a Rule 22 has been able to bring in their electronics, so I think that's a non-issue. The issue for us for access for jury selection is kind of because of the interplay of Rule 22 and the access for jury selection. So basically, because of the way Rule 22 operates, we cannot record, and the court's decorum order, we can't record the jurors' faces and we can't record the potential jurors' voices. So if no one from the media is allowed in the courtroom or in the overflow room, it's basically closed. We basically have a closure issue because there's no way for them to see what the potential jurors, there's no way for them to see what's going on in the courtroom and what the potential jurors are saying. So what we've asked the court for basically is for a small number of seats in the courtroom for the media that they can decide amongst themselves who has, so someone can see what's going on in the courtroom, and then the use of the overflow room, like a live stream in the overflow room that wouldn't be recorded, so it would serve kind of as an extension of the courtroom. So a way for them to see what's going on in the courtroom without being physically present in the courtroom, given the size and the COVID restrictions and whatnot.
And then you said there was a third issue?
The third issue was the electronics issue, which I believe is a non-issue.
So really the two other ones that are access by the pool in the courtroom and then access by the media to jury selection in the jury assembly room.
Exactly, Your Honor. A live stream in the jury assembly room, because we can't record, because when the pool takes it outside, they wouldn't be able to show the jurors' faces, they wouldn't be able to record what the potential jurors are saying, so there's no real kind of access outside because of the restrictions of Rule 22.
Okay. Anything from the parties on the matter?
No, Your Honor.
Judge, our only concern is that the jurors remain anonymous. We trust that the media will be able to keep their names out of the picture, keep their voices out of the picture, keep their picture out of the picture. As long as that's in place, then we have no objection.
Is it all right if I speak from here? I think
That's fine. As long as the podium is being used, I think we can pick you up. If not, I'm sure somebody will let me know.
All right, I usually don't have that problem, but you let me know if it is. I've been in communication with Mr. Clyde and Ms. Gaither, and she kindly sent to me the authority upon which her clients rely in asking that the court leave individual voir dire open to the media folks that are in the overflow. And we've agreed that that's the case, that they'll be identified by number only, that there'll be no contact with jurors or prospective jurors by the media. There'll be no attempt to interview jurors or prospective jurors until the conclusion of the case and in the matter that the court allows, in the event that the court allows such a thing. There'll be no publication by any means of photographs, video, or visual reproductions, which would be sketches of any juror or prospective juror. Jurors' names are not to be used in the media discussion of this case during trial. But they do concede that there are instances in which a juror may be unable to provide a complete and candid response during individual voir dire if they know that the media has access, that anyone else has access to this very sensitive and private information that they want to reveal, that they need to reveal. So, based on the case law that Ms. Gaither sent to us, to trigger a consideration of an in-camera voir dire, the prospective juror must make an affirmative request. So, as a result, Your Honor, we are going to be asking the court, whether you do it to the panel, which may be more expedient, to let the jury pool know that if a particular juror has a significant and sensitive privacy concern in respect to a question that's been posed, the juror may request to speak to the judge and counsel separately regarding that particular area of inquiry only. And that's the concession that we've reached with each other, because the concern that Ms. Gaither's clients had was that we had originally asked for a wholesale closure of the courtroom during individual sequestered voir dire.
All right, so one of the challenges in this case is going to be the questionnaire that was sent out, and I find it hard to believe that there aren't going to be, well, if not every individual that's going to come in is going to end up having to respond to questions about the questionnaire. What I imagined would probably happen with that was that would be done in the courtroom as opposed to before the rest of the panel, because I do not want information from individual jurors about what those individual jurors may have learned about the case being discussed amongst the entire group.
Yes.
So how is that going to be addressed?
Well, as we understood your original order, you were going to conduct the statutory questions, provide those to the panel, which you'll be bringing in 20 at a time, as we understand. And after you've gone through the statutory questions, each side will ask their general questions, but the only thing that juror can do is to raise their hand if they're answering in the affirmative. We're then jotting down those numbers, and the only conversation that's going to take place will be an individual voir dire. So there will be no tainting of the panel of 20 if the individual voir dire is the only place that we cover their knowledge of what they believe they understand and know about the case.
We're all in the same place. Okay.
Thank you, Your Honor.
All right. Mr. Gall.
Your Honor, we have nothing to add.
All right. So and I need to then make sure I understand exactly what's going on in the jury assembly room. I don't have an issue with permitting pool access into jury selection. The problem is the amount of room I have. We are very limited on room. So, and that applies also to the courtroom itself. What I will look at in order to address the issues that are brought up is whether or not we can get a pool reporter into the jury assembly room. And then I need to work through exactly what to do about the courtroom itself. And that should permit, and I believe the jury assembly room is being live streamed. I thought there was a camera in there.
My understanding is now the camera that's in there is the same pool camera, so it's not recording it wouldn't record what under Rule 22 exactly what the potential jurors are saying, so it wouldn't be a true live stream. Because it's the pool recording camera that wouldn't be showing the faces of the jurors or the voices of the jurors.
So what you're looking for is, in addition to what is being pushed out as images, some access to a pool reporter just to report on what's happening in the room.
Well, yeah, exactly. A live stream of what's happening in the room, yeah. As well as...
What do you mean by a live? I'm not going to permit an extra recording. What I think I'm prepared to do is allow a pool reporter in to report to the pool on what's happening there. But if there's already images being pushed out, and that's what I'll check on, then that's covered.
But our concern is the images aren't being pushed out because under Rule 22 it wouldn't be duplicative of what's in the courtroom, because you wouldn't be getting the potential jurors' voices, the answers to the questions. You wouldn't be getting any images on who raises their hand, who doesn't raise their hand, et cetera, because of the recording prohibitions under Rule 22.
I'll look at what the live stream is out in there. I'll just have to check and see how we're set up. One of the challenges being a Chatham County judge coming into Glenn County is that I'm not exactly sure how they've got it set up right now, but I will make sure that we do that before we get started.
Understood. Thank you, Your Honor.
And Your Honor, we have one other logistical issue that coincides with that, and that is how you would want to handle an in-camera sequestered voir dire inquiry. Whether that, the authorities provide for it happening in the courtroom if the courtroom's cleared, but that could get kind of tough. The other is that it can be done in camera and in your chambers, in your current chambers.
Yeah, well, let's address that if it comes up. We'll see what the status of the courtroom is and how exactly logistically we can do that. Because we can either do it in here and just shut everything down and clear it. I agree. That may not be as easy as you've indicated. But if we need to do it in the back, there's more than enough room, I think, in the back to do it.
Yes. Thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right, thank you. All right, there's also another motion to intervene. Filed by, let's see, Mr. Bauer on behalf of WXIA TV, WMAZ TV, WJXX, First Coast News Jacksonville. Is anybody here on the intervener's behalf? Let's be clear about it. I've got a motion and a request for an emergency oral hearing filed on October 14th at 7:15 p.m. on behalf of those interveners. Is there anybody here on behalf of those potential interveners? Can we check in the hallway? All right. I understand there is, although there are representatives of the media organizations that are referenced in the motion, I do not have counsel here on that request for an emergency hearing and the motion to intervene. The court is denying the motion. All right. Those are the motions to intervene that are currently before the court. Let's go ahead and move on to issues with jury selection. So to get everybody where I am on this, I received from the state as well as the McMichael defendants proposed general questions to the panel. I've reviewed those. I'm happy to hear from the parties on the proposed questions if the parties wish to address the court at this time. So let's start with the state's proposed questions. Ms. Donkowski.
Yes, Your Honor. The state did submit a list of general voir dire questions to you. At this point in time, the state has some concerns about the defendant's questions. Did you want me to address those first?
I was going to take it one at a time because I know I've received something at least from Greg McMichael's counsel on the state. So I just want to make sure that and I guess let me be a little bit more clear. What I received, it was a little while ago, so I want to make sure we're all on the same page. There is a set of general questions. It looks like it's 7 pages long that the state intended to use. I assume the state is still going to be asking to use those questions in general voir dire.
Yes, Judge. Those are our questions that we submitted a couple months ago. We are still intending to go forward with those particular questions.
All right. And I received a objection from Mr. Hogue. I'm not sure whether counsel had coordinated on that or not. So
We're together on that.
So Mr. Hogue, the state's general questions.
Yes, Your Honor. So the first objection we have is to the very first statement. It's not really a question. The state says, I am not going to ask you a series of questions, or I am going to ask you a series of questions, but before I do, I want to let you know that this is not a death penalty case. Our objection to that statement is that it's unnecessary to raise the subject of the death penalty in voir dire or at any other point in this case. Other than this question, the subject of the death penalty should never arise unless a juror during voir dire brings it up and asks us if this is a death penalty case. I think that's highly unlikely, but if they were to do that, then we just answer them and tell the individual juror, no, it's not. You don't need to worry about that. Raising the subject of the death penalty in general voir dire to all these potential jurors, I think would engender more questions than it purports to answer. A juror could wonder, for example, whether this could have been a death penalty case, whether it may have been a death penalty case at one time and the state's taken their notice off, or wonder why the state isn't seeking the death penalty. Those are the kinds of questions a juror could think up once they hear the words death penalty and begin to wonder, why did you tell us that? So it's unnecessary in examining jurors regarding any matter about which they might have an inclination or a bias or a leaning to bring up the death penalty. So we object to that first statement on that basis. I have other comments. Do you want me to stop?
Let's get through all of them.
Okay.
Instead of addressing.
One concern is just a matter of clarification, and I think based on what I'm hearing this morning, it may be cleared up. But one of the questions the state asks is, do you know me? And in parentheses it says Judge Walmsley. So I took it from that at least when they wrote these, the state was thinking that the court was going to propound all of these general questions. But I'm hearing this morning responses to my co-counsel, by your honor. Sounds like you're allowing counsel to propound the general questions. Okay. The next one I have is at the bottom of page 3. I have an objection to the question, is there anyone here who believes that the assistant district attorneys are from Atlanta or are associated with the Fulton County District Attorney's Office, formerly under Paul Howard, now under District Attorney Fonnie Willis? Our objection is that that question is unnecessary and irrelevant. Whenever the assistant district attorney or the DA and all the other assistants that are with the state are introduced, I imagine that the jury will hear that they are from Cobb County. I doubt any juror here will be confused to think that Cobb County is somehow affiliated with or within the Fulton County government in some way. And so injecting Fulton County, former DA Paul Howard's name, current DA Fonnie Willis's name into voir dire is irrelevant to examining jurors about any perceived impairment they may have or any inclination, leaning, or bias they may have. So I think it's probably more confusing to raise that question than it solves. The other objection on it's on page 4, is a question, are any of you related by blood or marriage, third cousin or closer, to the defendants Greg McMichael, Travis McMichael, or William Bryan in this case? The kinship question was included above. I may have added it, I can't remember. It looked like the first set of questions on page 1 were the statutory questions from 1512-164.
An expanded group of statutory questions.
They were expanded, but whenever I saw a statutory question that should have been included, I went ahead and included it, but I put it in brackets so the court would know and the state would know that in the digital version I sent this morning, anything in brackets is what I've added to it. So that kinship question already appears on page 1 in the statutory questions. So the only objection there is it's repetitious. You would have already asked it. Same with the bottom of page 4, any relation by blood or marriage to Ahmaud Arbery is a kinship question that should have been covered already above in the statutory questions. But I presume the court will be asking, and if not, I'll be moving the court to ask the statutory questions rather than the state.
Just so we're clear, normally I just have the clerk read the statutory, or ask the statutory questions on behalf of the court.
Yeah, anybody but the state will be satisfied with that. And I'm going through the notes here. That was all I had on the state's general voir dire questions, Your Honor.
Mr. Bryan?
Your Honor, the only question I have a problem with is there's a question in there not asking the jurors whether they know or know of counsel in this case, but asking about their character and reputation. At least that was in an earlier draft that I saw. I have no objection inquiring of the jurors as to whether they know or know of counsel and how they know them and whether that would affect their ability to be fair and impartial. I think that's fair game. But the question is phrased is highly improper, and I will move for a mistrial if that question is asked as phrased.
All right. From the state on those objections?
Yes, Your Honor. Your Honor, through the state's experience, having picked numerous juries, especially after the court has read the indictment, this indictment has murder, felony murder, felony murder, felony murder, felony murder in it. And jurors often assume, because they've been called to a murder trial, that this would in fact then result in potentially being a death penalty case. And normally, when the judge asks the statutory question, can I be fair and impartial, you get a couple of hands that go up. And when you ask them, well, why can't you be fair and impartial? They say, well, I can't sit on a death penalty case. Well, if we haven't already informed them that this is not a death penalty case, then we get them answering, yes, they can't be fair and impartial because of that. Once that is removed from their mind, that the only thing they're going to do, which, by the way, the court is going to instruct them in their jury charge, that they are only concerned with guilty and not guilty. They are not to consider sentencing at all. And that is a charge this court will be giving them in the jury charges. And it's just a courtesy to let the jurors know that that is the only obligation they have here, is to come back with a verdict that speaks the truth, guilty or not guilty. And to take that particular burden of, well, it's a murder case, so is it not? That uncertainty. And I understand what Mr. Hogue is asking for is that, well, let them bring it up. But the problem is jurors are nervous. They are being questioned individually by all of us here. And it's very, very difficult for them, I think, to speak up sometimes. And to have something like that weigh on their mind, it would just be easier to take it off the table. The idea that saying the words death penalty is somehow going to trigger a whole bunch of stuff in their heads, well, reading a murder indictment is also going to trigger a number of things in their heads as well. So we are just asking that the court inform them that that is what it's going to be. It's not a death penalty case. It's going to be guilty or not guilty. And that's the only thing they're to consider for themselves in this process. Thank you on that one. With regard to the assistant district attorneys are from Atlanta and not associated with the Fulton County District Attorney's Office. Your Honor, obviously the state has interviewed the witnesses and spoken with them. And what the state has heard repeatedly from our witnesses, whether they be law enforcement or lay witnesses, is you all are from Atlanta. And I understand why. Glenn County and the district attorney's office here is part of a 5-county district judicial circuit. So what you have here, and what everyone's familiar with here, is a 5-county judicial circuit. We are from Cobb County. It is its own judicial circuit, but that's not commonly known amongst other people when it's Atlanta, Cobb, Gwinnett, DeKalb, Clayton. Well, all that must be one big judicial circuit in the city of Atlanta. We just want everyone to understand that we are an actual separate entity that is to the northwest of downtown Atlanta and not necessarily associated with the Fulton County District Attorney's Office. We would, of course, understand if that is something the court eliminates from our questions. And then lastly, I did have, is there anyone here especially familiar with Mr. Kevin Goff through reputation or association? And that was simply because he is the one local attorney that the jurors may actually be familiar with. We are from Cobb County. The other defense attorneys are not from Glenn County or Brunswick. He's the one who may be known. And I didn't mean anything by reputation or association. I just meant, have you heard of him? Do you know him? Have you ever worked with him? That was simply what was meant by that question. I can rephrase it if it would make everyone more comfortable. Thank you.
No, we have no objection to her rephrasing it, but as phrased, that's our...
Yeah, I assume it's really the question. Well, let me get to them one at a time. All right. So with regard to the state's voir dire, that first question about the death penalty, if it comes up through a question, that's fine. The court's not going to be, it's not going to be coming from counsel or the court. So that is not going to be asked as the first question in the case. Again, the statutory questions we'll go ahead and address through the court. The question, as far as to me, the whole thing about Cobb County versus Fulton County and Atlanta, that's not going to be asked. To me, that's more confusing than anything else. I mean, we're in Glenn County, and that may be something in the metropolitan area that is an issue or needs to be clarified, but here, we're making it clear, I think, through all of these questions that the Cobb County District Attorney's been appointed to try this case and will do so. So we're not going to be asking about Atlanta and Paul Howard and those issues. The familiarity with Mr. Goff, I would suggest, is there anyone here especially familiar with Mr. Goff or has been represented by Mr. Goff? That strikes me as a fair question. There are a couple of questions buried in here by the state that are covered by the statutory questions, for example, related by blood or marriage. I would suggest that the state go ahead and take a look through that just to make sure that we're not duplicating questions. I say this to all the parties. We're going to be pushing for time. I don't rush anything in a case, but I also don't want to just burn time for the sake of burning time. We have a lot of jurors that would like to get through the court in order to determine when and if we can have a panel in this case. And the longer we spend on each individual question and each individual phase, the more concerned I get about how this is going to go. So I only say that because there is some duplication in here. There is a question here the court noted that was not brought up in the objection. There is specifically is raise your hand if you or a close relative or very close friend has been involved in a citizen's arrest. That's a legal term. The court's not going to permit that question. There's also a number of questions the state is proposing about the use of a handgun. It goes from use of a handgun to does anyone have in your household a rifle or shotgun? Have you had to use a rifle or shotgun for a non-sporting purpose? Please raise your hand if you ever had a handgun, rifle, or shotgun pointed at you. My notes here was to narrow that down to one question, is whether or not anyone in the household owns a handgun, rifle, or shotgun. If the state wishes to follow up beyond there, welcome to do so. But the whole thing about, so we're going to limit those questions really to one, if that can be narrowed down. Also, as Mr. Hogue pointed out, these questions were drafted, it looks like, from the perspective of the court. And so there are a couple of questions, or a couple of statements at the end. I'm going to instruct you. The court's not going to be instructing the panel in jury selection on these issues of law. For example, well, unless they come up, and the court needs to clarify anything that's happening. All the instructions at the end, the court is not going to get into. And I think that addresses the court's issues on voir dire from the state. Does the state understand the court's instructions?
Yes, Judge. What the state will do is it will go ahead and consolidate. Do you or does anyone in your household own a handgun, rifle, or shotgun? And then the state would like to ask, has anyone ever carried a gun as part of their job or had firearms training? But we will consolidate those other 4 questions into one question for expediency. And yes, Judge, I did write this with the intention that you would be giving the general questions to the jury. I will pull out any of those questions at the very end that are as if you are speaking to the jury.
Okay. All right, then. I have proposed general questions from Travis and Gregory McMichael. I received, it looks like 2.5 or so pages from the defendants. That is what I have been working off of. Would that be Mr. Sheffield, Mr. Rubin, Mr. and Mrs. Hogue? I assume these are the questions that are being proposed by those defendants.
That's correct.
Yes.
Yes, Your Honor.
Anything the court needs to address in there before I ask for any objections?
Not from us, no. Those are the 30 questions we propose to ask.
Anything from the state?
Yes, Your Honor, we have several objections. First off, regarding number 10, I'm assuming this is asking the jurors, does anyone here agree with this statement that no one should be allowed to shoot an unarmed person under any circumstance? This is basically calling for prejudgment on the particular facts of this case. And then number 11, I'm assuming once again that they would ask it in the form of, is there anyone here who agrees with this statement? No one should ever put him or herself in a situation where he or she might have to use a firearm for self-defense. Once again, state objects to that. It seems as if it's prejudging, and it's basically asking the jurors to put themselves in the position of the defendants, and we would object to that. Regarding participation in any of the demonstrations or marches related to the social justice movement before or after the death of Ahmaud Arbery, that question has absolutely nothing to do with what the defendants did on February 23rd, 2020, and participating in a constitutionally allowable peaceful assembly about social justice has absolutely nothing to do with these defendants, so we would object to number 12 as well. Number 13 is, do you support in any way the Black Lives Matter movement, where support includes positive thinking or positive thoughts to financial support to signs or bumper stickers or statements on social media? Once again, Black Lives Matter has absolutely nothing to do with this particular case. I'm going to suggest an alternative, which is, what bumper stickers or magnets do you have on your car? Do you have yard signs? What do they say? That question, I think, would go ahead and elicit a better response as to where that person may stand with what they put in their yard or communicate on their car to other people. And number 14, do you believe that anyone who opposes the Black Lives Matter movement is a racist? There's absolutely no evidence in this case that anyone involved in this case opposes the Black Lives Matter movement. That also goes with talking about that movement and demonstrations having a positive effect on the community. That's number 15. We object to that. And 16, do you agree with the statement? This case has been important in revealing the racism in our community. Well, what has that got to do with the guilt or innocence of these defendants? About the aftermath of this case and everything that took place? Asking about whether the media has done a good job covering this case fairly. Once again, we'd object to that. That was number 17. Number 20, we object to, do you agree with this statement? The Confederate flag is a racist symbol. Same question for the old Georgia state flag.
We have that as number 19, Your Honor.
I'm just 20.
That's
So the state flag.
We got one off somehow.
Okay. Once again, 23 is sort of in the same bucket with the asking the jurors, do you believe this makes this person a racist? Do you believe this makes this person a racist? So there's a propounding of a number of questions where they want the juror to say, I guess, that, oh yeah, if somebody does this, I automatically think they're a racist. Those sorts of questions, I think, are inappropriate, especially for voir dire. Number 23, white people who use the N-word are racist. Getting them to agree or disagree with that statement. I believe we've got number 24, which is very similar to the citizen's arrest sort of question, which you've already excluded from the state. Do you believe that a citizen should never attempt to detain a person suspected of a crime under any circumstances? So once again, we've got prejudging, once facts not in evidence, and calling upon a legal concept there. Number 25 is regarding mental health. To ask this question in this context, we've already ruled that this is inadmissible evidence. So asking this sort of question in voir dire is inappropriate because it's not going to come in. That also holds for number 26. If I may have one moment. Your Honor, we're very concerned about number 29. This is sort of the, are you concerned about your safety, your reputation, or your livelihood if you were to be a juror on this case? That's the please feel free to raise your hand and give us some excuse because we've just told you that we'll consider this. People serve on juries every single day in this country. They serve on murder cases every single day in this country, including cases that are televised or that are controversial. So at this point, to ask that question is just basically asking every juror to raise their hand to be asked to be let off this jury. And those are our objections, Your Honor.
Mr. Hood.
Yeah, there's a keyboard and a mouse right here on this lectern. I presume I can move that. I don't know who put it here or what it's for.
It is not mine.
You can't do that.
Thank you. I'll just put it down here. In fact, I'll stick that down here if you want me to. Thank you. I believe the objections began at question 10. I'll try to stick with the numbering. I think we got off somewhere. I might have deleted a question after I sent those to the state and to the court. But with respect to question 10, The way we've phrased it is, no one should be allowed to shoot an unarmed person under any circumstances. Of course, it's a hand-raising question, and we would follow up in individual sequestered voir dire to talk about it. But under 1512-133, of course, the statute that guides us here on individual examination, without reading the whole thing, the important part is that we're looking for any inclination, leaning, or bias respecting the subject matter of the action. The question's designed to discover any jurors who may have an anti-gun opinion or anti-gun violence inclination, leaning, or bias, even in self-defense situations. While I think it's highly unlikely that jurors will say, I don't agree with the use of firearms, even if defending oneself to the death and using one. But violent gun use in self-defense is a subject in this case. And so under 1512-133, we're looking for any inclination, leaning, or bias respecting the subject matter of this case. So that's the defense to question 10. Would you like me to go forward and address each one?
If you could, please.
Then I think the next batch was, did you object to number 11? 11, okay. The response is the exact same as I just gave for number 10. It's 1512-133, inclination, leaning, or bias. Subject matter of the case obviously concerns the use of a firearm in what the defense will say is a self-defense. That's what's at issue. It is the subject of the case. And so this question, like 10, helps us look for jurors who might have an inclination, leaning, or bias, so that we either may find out if they're legally impaired and move to excuse the juror for cause, or use a peremptory strike, which is, of course, the purpose of voir dire, is to determine which jurors may be impaired and which jurors we would like to strike with our peremptories. The next questions were all of those in the group, I believe, from 12 down to 21, maybe. I tried to take notes quickly, which questions the state objected to, but all of those have the same defense, 12 through 21, so I'll just state that. And again, it's our dependence on OCGA section 1512-133 concerning the subject matter of the action and our efforts to find jurors who may have an inclination, leaning, or bias that would help us determine whether that's a juror that should or should not sit on our case. So each of those questions achieves that by asking. We do know that race is an issue in this case, and naturally we would be allowed to discuss race. And these are just ways to get at that and find out from potential jurors whether they might have inclinations, leanings, or biases that render them unsuited for this case. Now, I haven't discussed with co-counsel, but let me look here. One of them I may withdraw. Let me continue with 12 through 21, and if I've got the numbers off, I'd like to clear that up. But I have 22 as the N-word question. Is that what everybody here?
No, I have it as 23.
23. All right, so I must have deleted a question along the way, but 23, I propose that we withdraw that question. Co-counsel.
23.
It's 22 on your list.
Let's make sure.
It's the N-word question. This one right here. withdraw question 23, the N-word question. But if I can back up just a minute, I see I have other notes to defend questions 12 through 21.
You don't need to do 20 or 21 on your list. They
Okay.
didn't object to those.
Okay.
And
then-
they didn't object to your 18.
All right, so it's, just so we can get the record clear, which
12 to
questions?
17 on yours.
12 through 17?
And then 19 and 22 on yours.
Okay.
And then 23 through 26 on yours, and 29 on yours.
All right, so the defense to 12 through 17 then, yes, the follow-up in individual voir dire with those questions could develop for us and explore a juror's thoughts and opinions on those matters in order to determine whether a substantial impairment may exist such that a cause strike is supported, or if no substantial impairment, then enough information, and now I'm quoting from a case I'll cite. The quote is this: to enable counsel to identify those prospective jurors counsel desires to remove from the panel by use of peremptory strikes. That's Henderson v. State, 251 Georgia, 398 at 399, a 1983 case. And then also citing a U.S. Supreme Court case, Turner v. Murray, M-U-R-R-A-Y, 476 U.S. 28 at page 36, quoting, a defendant accused of an interracial crime is entitled to have prospective jurors informed of the race of the victim and questioned on the issue of racial bias. Those questions are designed to get at possible bias that's based or related in some way to race. All right, and Laura, help me out. What's the next one? 19. Nineteen is the Confederate flag question. And we actually, this is how I got off. You have a Confederate flag question and an old Georgia state flag as a separate question, Your Honor, in the state, or no?
My number 20 is combined. Do you agree with this statement? The Confederate flag is a racist symbol. Same question for the old Georgia state flag.
Okay, I have that as 19, but that's the question, and it's two questions in one, and I was wondering maybe that's how our numbering got off. Yes, those questions, again, under 1512-133, help us explore any inclinations, leanings, or biases any jurors may have regarding the subject matter of the case. Many people, of course, consider those to be racist symbols. Most people perhaps do. I don't know. That's one of the reasons we want to talk about it with jurors. And so we want to follow up. If anybody says, yes, I think those symbols, the old Georgia state flag, which we presume will be a part of the case now, if I get told right here, right now, that that's not a part of the case, then I'd like to withdraw the question. I've tried to pick questions here that are indeed related to the subject matter, no matter how small it may be in this case. And there is an old Georgia state flag tag on the front of Travis McMichael's truck that's visible in some of the body cam video that we've received in discovery. And I believe there was some discussion at one of our motions hearings, and I can't remember which motion or how it came up, regarding the admissibility of that image. There's no evidence we expect in the case that Ahmaud Arbery saw it on the front of Travis McMichael's truck.
That matter was not addressed at our last motion hearing. I believe the motion in limine was filed after the last motion hearing,
Okay.
so it's still pending.
All right. Well, without knowing which way the court may rule on that, or which way the state may intend to present their case with respect to it, this question we wrote anticipating that it would be or could be admitted into evidence. And again, if it's not going to be in the case, then we don't want to ask this question. We're only asking it in case that image is part of the case. And so going on.
To your 22?
22. We withdraw 22. I don't know if that's your 23. That's the N-word question.
My 23.
Yeah, we're withdrawing that one.
Then your 23 to 26.
All right. Again, 23 is the media question, whether the media has done a good job covering this case fairly. You know, our concern, Your Honor, here is that
We're off then. That is not what I have.
the,
That question is much earlier on, I believe. So my 23 is the question about the N-word. My 24 is, do you believe that a citizen should never attempt to detain a person suspected of a crime under any circumstances? 25 is, do you think that a psychologist or psychiatrist can find a mental illness in just about everybody? And then 26 is, do you think that mental health professionals prescribe medication too often?
so you don't have the media question at all, it doesn't sound like.
I believe it's number 17.
Oh, maybe that's how I got off. Okay. 17 is the media question.
That's what I have.
I may have moved it then, but I have it here as my 24, or 23 rather. And the question is, do you agree with this statement? The media has done a good job covering this case fairly. Again, the defense to the question is that is under 1512-133 again. It's designed to discover inclination, leaning, or bias in favor of the state and against the defendants based upon a belief that media reports on this case have been accurate, complete, and true. And in the beginning especially, it has changed some, but in the beginning, the vast majority of media coverage characterized the defendants as white, racist murderers who saw Ahmaud Arbery in their white neighborhood out for a Sunday jog, and so they got in their truck with guns, chased, trapped, and executed him. In fact, those are the exact words that the state used in the preliminary hearing in June 2020. And that got widely reported. It was said right here in this courtroom. And so many people who might think the media has done a good job, and by and large the media does do a good job, but if they latched on to those early reports and fixed their opinions about the case based on those are jurors we'd like to talk to and find out if that's the way they view this case, and we're not able to move them from it. So the next one is that was objected to is the citizen should never attempt to detain a person suspected of a crime under any circumstances. Here we're looking for potential legal impairment. We expect the court will give the jury the charge at the end of the case on the citizen's arrest statute as it existed in February 2020. And if there are jurors who are unable to follow the charge of the court, couldn't consider it as a potential defense, not that they have to accept it. We're not looking for a prejudgment. We're not offering a hypothetical. How would you vote if these were the facts? We're asking whether a juror can give meaningful consideration to a law that they will hear and be able to decide whether the facts of the case fit within that law or not. They can decide either way, but if they say up front, we don't believe a citizen should ever attempt to detain a person suspected of a crime, no matter what the circumstances are, then that is somebody who is legally impaired and unable to be a fair and impartial juror with respect to the subject matter of this case. So 1512-133 is our defense. And then is it the mental health, number 26,
5 and 6 on yours.
25 and 26? Yes, I know that there's been a pretrial ruling concerning the mental health issue related to Ahmaud Arbery. Our concern in not asking the question, though, to the jury and exploring this is that there's a possibility that the trial itself might change the court's ruling, and that mental health may actually come into the case at some point. There's a possibility that either the state would inject it or open the door to it from the defense side, and the court would need to then revisit that ruling. And if that happened, and we have jurors on there who have attitudes that might have been learned by asking these two questions, those would be jurors we may have stricken had we known their views. So, go
I
ahead.
can interrupt with that issue. You realize Mr. Hope's just gotten out of another trial, so there were a few things filed while he was in trial, and one of those is a motion in limine by the state to prohibit the defense from introducing the second toxicology report, which has the absence of Zyprexa and the presence of THC. And that is still pending before Your Honor.
So these questions would go to that
Yes.
issue. Yeah, there you go, Your Honor. What she said.
Yeah, let's, and I understand the issue there with trial, but we're going to keep one counsel at a time on issues, so.
All right.
And then 29 on yours.
Yes, our concern here, and again, this is a 15-12-133 question. This goes to any inclination, leaning, bias. If a juror was concerned, for example, that if they were on our case, heard the case, and then honestly thought that the correct verdict would be not guilty, and yet had thoughts in their mind or discussion among their fellow jurors that if we do acquit these defendants, our own safety may be at risk, the safety of our family, our reputation, our livelihood, our business, all of those could be legitimate concerns based on what has happened in the United States in the wake of jury trials going way back, not just in the recent year and a half, but we've seen it many times where communities are thrown into great chaos after a courtroom has engaged in a trial and a verdict's been reached. And it's not unreasonable to think that some jurors who live here in Glenn County would come into this case with those concerns on their mind. And it could influence, I'm not saying it will, but it's possible that it could influence the verdict they choose. So that's the reason for that question. It's a 15-12-133. I think that's it.
Mr. Goff.
Yes, Your Honor.
I have a brief point to make on it as well.
Your Honor, first, for the record, we don't believe this is a case about race. We're aware that that's come up. We don't believe that, but just because we're not at submitting independent questions to the court, we're counting on the counsel for the state and the McMichael defendants asking these questions. I want to formally adopt, say, for example, a plane crashed into the Hoag's Hotel tomorrow and they disappeared from this trial. I would probably ask most of the questions that they've got. I specifically want to adopt 10, 11, 13, I'm sorry, 12, 13, 14, 20, all the way from 12 to 21, 23, think 23 they withdrew, 24, 26, 29. We would want to adopt those questions for the sake of preserving the record for appeal. It would be an awkward circumstance if the McMichael defendants were granted a new trial because their selection was restricted, and Mr. Bryan didn't get the benefit of that because we didn't formally preserve the right to ask those questions on the record. And beyond that, I have nothing further to say.
Thank you, Mr. Scott. Mr. Shepard.
Thank you, Your Honor. Just to add a little bit of context, the question on the Confederate flag was also raised because we understand from discussions with the state that they intend to make it an issue in the case and perhaps to argue its relevance to the decisions made by the McMichaels on that day. And so for that reason, we included it because we thought it would essentially open the issue, not call for a narrative response, just a hand raise that we could follow up then. The other issue that we have, Your Honor, is about the psychologist, psychiatrist, mental illness, and the prescription issue. Again, these are just ways to get jurors to identify themselves through a yes answer that they have some personal experience or personal opinions about these things. The court has ruled that Mr. Arbery's medical records cannot come in. The court has so far ruled that we can't put in his diagnosis or the fact that he was being treated for a mental disorder. However, there is evidence in the case, and we think it'll be in the state's presentation as they begin to offer statements from Travis McMichael. Several times Travis mentioned to the officer when he gave his interview that he noticed something was off or wrong with Mr. Arbery in the way that he was responding, not communicating, and that caused him to make decisions that day not to further engage with Mr. Arbery as he was trying to keep an eye on him. So to the extent that Travis made observations about Mr. Arbery, he reported those, we do believe that there will be a minimal bit of evidence about something was off or wrong with Mr. Arbery on that day. So for that reason, we think these questions should be allowed in addition to the reasons that Mr. Hope put forward.
All right. As to the defendant's general voir dire questions, then the court has reviewed the questions, and the following will be excluded from the general voir dire. What I have is number 10, about shooting an unarmed person under any circumstances. The court finds too broad. I don't have the actual cites, but I got the names of the cases. There's Holloway and Stewart, I think, are the two cases the court looked at. Number 11, one should never put him or herself in a situation where he or she might use a firearm to defend themselves. The court finds that that's too close to prejudging evidence in this case. It's Kyles and Stewart. I'm going to permit 13. 14, do you believe that anyone who opposes the Black Lives Matter movement is a racist? I think we covered the Black Lives Matter movement in 13, and the court is going to permit some of these other questions that touches upon race, but again, I don't want to spend 10, 12 questions dealing on that issue. So 14, again, Black Lives Matter is not a party to this crime, party to this case, not part of the criminal prosecution, so that's not going to be permitted. As far as the case being important to revealing racism in the community, again, the court's not going to permit that for similar reasons. As far as
I'm sorry, I could not hear what you just ruled.
I said for the same reasons. Do you agree the statement that this case has been important in revealing racism in our community, again, is a general voir dire question. The court finds that overly broad. 17, do you agree with this statement? The media has done a fair job covering this case. Again, that's overly broad and potentially prejudging. Now, and again, well, in line with that, we don't know what they're referring to. There's an entire questionnaire about the media that the parties are going to be able to follow up on. Let's see, working down. The court's going to permit the question about the Confederate flag.
Honor, I'm sorry.
I think it's the mask. It's very difficult to hear you, but did you say you're admitting it or omitting it?
Permitting.
Permitting. R19, the flag.
Go.
The question about should a citizen never attempt to detain a person suspected of a crime under any circumstances, that's a legal principle. I understand the defense's request or how it was couched. The question the court would permit would be whether or not the jurors would be following the law. But again, that as far as the way that particular question is asked, the court's not going to permit it. The court is going to permit 25. Do you think that a psychologist or psychiatrist can find a mental illness in just about everybody is permitted? But the second question about prescribing medication, no. Again, those issues really aren't before the court, but I will allow the question simply to see if that fleshes out any additional follow-up with any particular juror. And then 29, are you concerned about the safety, reputation, or your livelihood? The court's not going to permit that. There is a general question, I think, in the states questioning about hardships. Hardships are important as far as the way it's presented in the defendant's questioning. The court's not going to permit it. But the court will permit the remainder of the questions. Any questions about that from the defendants?
Judge, with regard to question number 29, I would submit, I don't know if my co-counsel would agree with me, but that number 29 is perhaps the most important question that should be asked.
Let me touch on this. This is a case that has garnered significant attention in this community as well as around the country. And I have no doubt that the 1,000 or so individuals that were summoned, when they received that summons, reacted in some way to that, whether that was due to a concern for safety, due to their reputation in the community, how that might be affected if in fact they do participate. This is not an easy thing for anybody. And so I have no doubt that if you ask that question, you will get a response from almost every individual that it affects them in some way. It affects you. It affects Mr. Sheffield. It affects Ms. Dunkowski. It affects everybody in this room. It affects the defendants. It affects the families. So that's why I'm not going to permit it, because as far as a hardship and whether somebody should be struck for cause, that's not going to be relevant to the court.
I'm not suggesting that it would be a challenge for cause necessarily, but if someone does raise their hand and feels that their business is at risk, that their livelihood is at risk, or their children are at risk, we might want to exercise a peremptory challenge on that.
Again, that question is so broad. If you can figure out a way to tailor that in some way that doesn't effectively have everybody raise their hand under the circumstances of this case, I'll consider it. I understand the question, but the way it's placed here, given the case that we're involved with here, the court's just not going to permit it.
Okay, thank you.
Obviously, the question needs a little work, but the Glynn County Courthouse Annex opened an hour later today, supposedly for some other reason that I think everybody in this town believes it was a security issue. Businesses downtown, as we are sitting here, are deciding whether they should board up their
One thing, Illustrator, when I put my hand up like this, you need to stop. Here's the court's position. The more we talk about this, the greater the issue becomes. We're trying a case. Okay? We're going to get a panel in, and there are issues that we need to work through. This particular question, as it is phrased, is not going to be asked. Okay.
So, Your Honor, let me clarify, because I want to make sure I have this correct. Defendants 10 and 11 are out, but number 12 and number 13 will be allowed to be asked. Number 14 is out, but number 15 will be allowed. Is that correct?
No, I didn't notice 15. See, I don't remember discussion about 15. I believe that these movements and demonstrations have had a positive effect on the community. Yeah, I think that's the same as 16. That's out. 15 is out.
Okay, thank you, I just wanted to make sure. 20 is in, 23 was withdrawn, 24 is out, 25 is allowed and permitted, but 26 is out and 29 is out. That's what I have.
That is correct.
Thank you, Your Honor.
All right. Strikes. Have the defendants discussed, and I know there was a request for additional strikes, but let's start with the statutory strikes. The 9 strikes, do the defendants intend to divide those up? Are they going to be used jointly? Has there been any discussion about that?
I believe what we would like to do and hope to do is that all of the defendants will agree on all of the strikes, however many we get. I mean, that would be ideal, rather than, I think the McMichaels teams will certainly agree on all of our peremptory strikes. I have not discussed it with Mr. Bryan's counsel, so I'll let them speak to that, but ideally, I'd like for all of us to agree on how to use our peremptory strikes, however many we get.
Mr. Goff.
Your Honor, I'm always open to agreeing with counsel on anything, and it would probably facilitate jury selection if that were possible in an ideal world. But I have an abundance of caution. I want my 3, 5, 10, whatever number of strikes it is, I want the ability to exercise them independently if there is a difference. Now, if we're not going to use them, we could entertain a request to cede some of those, but I want 1/3, the right to exercise 1/3 of the strikes that are available to the defense.
Well, that court put the court in a position where I'm going to have to divide up the 9 then. Whether they're used jointly amongst the McMichaels, that's really up to the McMichaels if that can be agreed, but it sounds like we don't have full agreement across the board. So from a starting point, the strikes will be divided up 3, 3, and 3. There was a motion for additional strikes. Let's get specific on the numbers that folks are requesting. So if the defense is prepared to go ahead and address that, and then the state also will go ahead and address that.
Yes, Your Honor, we did, in July of 2021, in a motion we filed, number 5.4, which I guess is the motion on the table right now. At the end, we request the court exercise its discretion and grant each defendant an additional 5 peremptory challenges that the defendants would exercise jointly. So that would take us up to 14 total. I think we can figure out how to divide them, is that right? See the last sentence.
Yeah, my understanding from the motion was there was the request, I'm permitted to go up to 5. The court has some discretion here.
Per defendant.
Per defendant.
Yeah, that's what we asked for back in July.
Yeah, that was my understanding.
So 15. Yeah, yeah. 24.
24 strikes, Your Honor, that's what we're looking for.
Okay.
Sorry about that, guys.
From the state.
Your Honor, we would request the same amount of strikes as the defense. We don't believe 5 each is necessary. That seems like a bit much, but we would just ask in fairness that the court give us the same additional amount of strikes.
I'm curious to know what the basis is for it being unnecessary, from the state's opinion.
Well, Judge, it's just that we need to get a jury in the case, so 15 additional strikes just seems like a bit much, but of course it's within this court's discretion.
If I may be heard.
Yes.
Obviously, we will accept all the peremptory challenges that the court will provide. We're happy to have them. I'm just not used to seeing the state use all the strikes that they have, much less ask for more. I think the rationale for the defense getting extra strikes is completely separate and apart from that of the state. But obviously, it's within the discretion of the court.
Let me ask, is one of the issues the court needs to work through is on alternates. We're carrying a number of extra alternates. And I don't need an answer from the parties right now, but I do want to think through numbers. Normally, it's one strike per alternate. And that's going to add a lot of strikes into the alternate pool. And it's been done a couple different ways, and I've done it a couple different ways. And if it was one strike per alternate, it's one strike per alternate per party, which means 4 strikes per alternate. That's a considerable sum. I'm going to propose, and I'm not asking the parties to agree to it now, but if there can be some discussion, particularly on the defense side with regard to alternates and strikes, that may be helpful to the court, if that can be consolidated in some way or some sort of agreement, because that would help with numbers, because that's really where the numbers start adding up considerably. But I don't think we need to reach that until we get to actual selection.
How many alternates are we looking at?
I can carry, I believe the way we've got this set up is I'm going to be carrying 4 alternates, which again, with 4 alternates, that's a considerable number of strikes on the back end. Okay, so we'll revisit that at some point. I just wanted to plant that seed. Okay. All right, the court's inclined to go ahead and grant, well, first of all, we'll divide up the statutory strikes amongst the defendants, 3, 3, and 3. The court's going to grant the request for 5 additional strikes for each party. The court is also granting the state additional 3 strikes, giving them a total of 12. So that's how we'll go ahead with strikes. Does everybody understand the court's instruction on that?
We do, Your Honor. Thank you.
So each defendant will have 8 strikes in this case.
Correct.
Thank you, Your Honor.
And the state will have 12. There was a reference during the argument or the presentations to the court on general questions about the court reading the indictment. Every court does this a little bit differently, and I realize we have lawyers from a number of jurisdictions, so I do want to explain how I do it so that there's no confusion about it. In my opening to the panel, I do not read the indictment. I don't read the indictment during jury selection, and I do not read the indictment during my preliminary charge. I simply reference the charges that are there. The indictment is the state's statement on the charges itself. The court's position is it's up to the state to explain the indictment, and just reading it doesn't do that. The court's instruction also instructs the panel to refer to the indictment if there are any questions about the charges that are brought by the state. So again, the court does not intend to read the actual language of the indictment, just the charges themselves. Want to clear that up before we got into it.
So, Your Honor, that's what I'm understanding you saying, is that in opening statement, if the state then goes through, this is what they're charged with, and this is the elements we're going to go ahead and prove, and this then segues into our presentation of what we expect the evidence to be, that's what you're expecting the state to do, because that's what the state would like to do.
Right, that it is the state's indictment, so the state needs to explain what the charges are and what they need to prove.
Great, thank you, Your Honor.
Okay, anything from the defense on that?
No, thank you.
Okay. All right, as far as jury selection then, anything further from the state? We've got, let's see from a timing standpoint, it's about 11:45, so we've got about an hour and 15 minutes before we bring the first panel in.
I need one moment, Your Honor. Nothing as it pertains specifically to the voir dire, and I just want to be clear. I believe that we came to a modicum of accord on the pre-charge, but that's the pre-charge after we get the jury. That's the pre-charge before opening statement.
I've gone through that. I have a draft of that. I'll go ahead and share the draft with the parties. I just haven't gotten around to doing that yet.
Thank you, Your Honor. So then you're going to go ahead and have the clerk or yourself do the statutory questions, and then the state will do its general, the defense would then do their general.
Correct.
Thank you, Your Honor.
Okay, and I'll coordinate with the clerk.
Thank you.
Is the goal, Your Honor, this morning that we will be handed over those questionnaires?
Yes, we should be, by the time we get started, which I believe is going to be happening, is you'll be getting a binder with each panel that has the questionnaires as well as the general information sheet that's been filled out for each individual member of the panel. Now, instructions on that. Those binders do not leave the courthouse. Okay? But those are, each party will have their own binder, which will contain a questionnaire for each one of the prospective jurors.
Okay.
Your Honor, let me understand the notion that we cannot take the juror questionnaire responses with us in the evening to work on decisions about...
I didn't actually say that. So are you asking to do that?
Yes, we are asking to do that.
So that information is for counsel's purview. It is not to be disseminated by anyone outside the part, or to anyone outside the parties. Now, understanding that the court is, well, that'll be a ruling of the court, and will subject to any party who violates that to contempt. We'll do it that way.
Absolutely. Thank you, Your Honor. The other is, we had asked the court in a motion 5.3 to withhold the identity of the alternate jurors until the close of the evidence. I don't see that the court's ever ruled on that. Is that something the court is going to grant to us?
Yeah, we haven't ruled on it. I will tell you, my practice is generally not to tell alternates that they are alternates, that they are all members of the panel. Now, they'll be numbered. I mean, they can try to work through it as best they can, but as far as I'm concerned, all 16 members of the panel are active jurors in the case until otherwise ordered by the court.
Very good. I think that keeps them more engaged as well. This is another issue with respect to voir dire or the jury selection process. Our motion 5.8 regarding the method of selecting the alternate jurors, the court had indicated in its trial notice, as I set forth on paragraph 2 of this motion, that...
Let me get there.
Sure.
5.2.
Yes, Your Honor. 5.8, excuse me.
5.8. Interestingly, I go to 5.7. So, when was it filed?
I see it stamped filed 5.8, motion regarding method of selection of alternate jurors.
Maybe in a different part. Go ahead, I'll
All right.
catch up with you.
Well, paragraph 2, I'm quoting your original trial notice where you said that once a jury of 12 has been selected, the same process will then be applied to the alternate juror selections, beginning with the next qualified panel member. It may have just been the way you wrote it, but it made me concerned that you were not going to afford us the entire qualified panel, that magic number of the 12 jurors, the number of strikes that the state has, and the number of strikes in total that the defendant has, and then proceeding down from that number into the selection of the alternates. I set forward an example of how that could be prejudicial really to both sides, but as the court knows, jury selection is a strategic matter. And so there may be strikes that we do not exercise near the end of the magic number of qualified jurors, which would mean that we have already, where the law says we get a juror to us, that goes to the state, they can accept or reject, then each juror, potential juror, must be put on the defense for us to accept or reject. If the court were to go directly to the very next number of the prospective jurors to begin the selection of alternates, it makes it impossible to have a strategic method of making decisions about striking or not exercising strikes. I think when you read the motion, if you could give some consideration to the idea that it's completely within your discretion, but for the vast majority of cases that we try, we know exactly where to draw the line at the magic number and where we're going to begin selection of alternate jurors. Otherwise, we could end up having to have that same juror put upon us twice and having to either choose or forego a selection more than once.
We may be overanalyzing this. We start at 1. 1 is either accepted or rejected. We move to 2. And then once we get to 12 qualified jurors, all that was supposed to indicate was we just start, because the alternates, the way the strikes work, you get a strike per alternate. That's the only reason I even put a reference in there to choosing alternates. Alternates get picked exactly the same way. We just keep marching forward. Whoever the next available juror is either qualified or is either struck or not struck as an alternate.
That is the method that we object to. That what we're asking for is that we'll all know where the main panel of qualified jurors ends and where the selection of alternates will begin. It won't change or delay or affect our need to qualify enough jurors for that to happen.
I understand what you're saying. I'll think that through. That's not the way I do it. I'll go ahead and take a look at your motion, and I'll take it into consideration.
I appreciate it, Your Honor. And then the next question we had was with respect to logistics, so that we can begin to have our charts prepared. When 20 people come in for the panel, where do you propose putting them, and how is this courtroom going to look so that we can make our charts?
Remember, we're not using this courtroom for the 20.
I did not know that.
Yeah, no, I've said all along, we're using the jury assembly room to impanel the 20, because that gives us a lot more room to spread everybody out. And then individual voir dire, we can move individuals into the courtroom for individual voir dire and keep the panel together in the jury assembly room.
Excellent. So we'll have an opportunity before then to go in there and see how do you have numbers on those chairs, or will you?
Are they numbered? Yeah, I think they're numbered. They're all marked. You can see sight lines if you want to go ahead and take a look at it before lunch. You can see where the sight lines are. We've done what we can for sight lines. We've done what we can for audio, and it's set up to work that way.
Very good. Thank you, Your Honor. And my last question, is the court able to tell us how many people showed up of the 600 who were summoned this morning?
I do not know.
Thank you, Your Honor.
Your Honor, I have two matters. Number one is I just want to be clear. When we're proceeding with the actual jury selection after all the questions are done, I presume we're going on the silent strike method. I just want to make sure, since I have my own separate allotment of jurors, that the bailiff is going to take the strike list to the state first, then to the McMichael defendants, and then come over to me. So I don't want to have to confer with them if I don't want to on exercising my strikes. So that
I'm happy to do it that way.
Thank you, Your Honor. The second matter is, it's never come up before, but it seems like a good idea. Is there any reason why, after the jury is selected, why we can't renumber the jurors with different numbers so they can't tell which juror is 1 or 12 or which are the alternates? Just reassign them a new numbering or lettering system so that they can't tell.
You guys need to shuffle the deck.
It looks like a shuffled deck. We haven't actually shuffled it, but it looks that way.
Remind me of that, Mr. Goff.
Yes, Your Honor.
Yeah, I don't think that's an unreasonable request. If I understand what's being asked, it's just if you're juror 1, your sticker could say you're juror 13, but you remain juror number 1.
Yeah, that way juror number 15 or 16 doesn't really know whether they're one of the actual 12 or not. So they'll pay more attention through the trial. And on that note, if it's possible, I really could use a bathroom break.
All right. Well, we are, as I understand it, then we have addressed the matters with voir dire. I believe we are ready to go. And that being the case, we'll go ahead and recess. What we'll do is I'm going to ask that we reconvene then in the jury assembly room at 1 o'clock. Anything further from the state?
Just as to when we would be receiving the binders, will that be before 1 o'clock?
I sure hope so.
Thank you, Judge.
Okay. Anything from Travis McMichael? Nothing from Greg McMichael. Take note. Mr. Goff.
Is the attorney workroom now been freed for defense counsel for use?
Nobody has updated me on the discussions, so I'm not aware of any changes. All right.
I believe we are in progress on that, and I do not have an update at this time, but we will attempt to figure out over lunch.
Thank you.
All right. Thank you. We are in recess until 1 o'clock.